Hi, I'm Alice Anderson and I'm an associate at Gill Jennings Every, an IP law firm in London and Munich. I've worked in IP for about 8 years and I'm a qualified UK and EU trademark attorney. I advise clients in relation to choosing, protecting and enforcing trademarks. I work with startups in the early stages of their company all the way through to multinational companies who have a much larger IP portfolio and need help with IP strategy and worldwide enforcement. So today we're going to be looking at intellectual property as it applies to the fashion industry. I'll be focusing on trademarks and brands, but my colleague Heather Scott has a parallel seminar that looks at design protection as it applies to the fashion industry. So do have a look at that if that's of interest. So the fashion industry is all about creativity and new ideas. And it's the expression of those ideas that is intellectual property. Every dress, every new handbag, pair of shoes or textile pattern is an expression of a designer's thoughts and ideas and has huge value in it. Intellectual property rights are a legal mechanism which allow you to protect that value in a piece of work to prevent counterfeits or copycats. And your IP strategy for the fashion industry needs to be fit for purpose, given how fast moving it is and that new collections and new pieces are made every couple of months or every season. Some of those pieces are going to have a shorter shelf life and some are going to be much more long-standing and classic pieces. So you need to adapt your strategy accordingly. So just coming up on the screen now are a few, I'd like to call them traditional trademarks. Those are kind of words and logos, letters and combinations of those, which are what we're quite accustomed to seeing as trademarks, and hopefully you'll recognise all, if not some, if not all of those. So words, Prada, the Lacoste crocodile. But it's also possible to trademark more non-traditional elements, such as patterns and shapes. So I've got a Valentino shoe there and a Chanel bag clasp, which are also registered as trademarks. Now, these shapes are more of the exception rather than the norm, but it is an important element of trademark protection and it is possible in some circumstances. So it's worth exploring what's going to be most appropriate for you. And I'll talk you through some of those options. So a trademark is essentially a brand identifier of your company, and a lot of time and effort and money goes into creating that brand, and registered trademarks allow you to protect that investment, to stop others from benefiting and counterfeiting your goods. A trademark also acts as a mark of quality for your products. They attract customers through brand reputation, and obviously if someone likes the quality of your product, they're going to buy it again and they're going to recommend it to other consumers, and they trust in that brand to keep delivering that same quality. So importantly, unlike a lot of other IP rights, provided they are renewed, trademarks can last indefinitely. So they're a really good idea to protect your house brand or long-running items as trademarks, because they'll be a perpetual right. So design registrations have a shelf life, and that's a real benefit of getting a trademark over a design registration if you can. And then similarly to other IP rights, trademarks are territorial in nature. So if you have rights in the UK, this has no bearing in any other countries. And you should look to register in every country where you're selling or manufacturing. Obviously, this starts becoming quite costly, so you have to prioritize and map this onto your business plan. So I wanted to give you a few more examples of the more unusual trademarks that can be sought. It is more difficult to obtain trademark protection in these kind of elements, arguably, but if you can, then it's something to look into. So shapes, colours, sounds, smells, or even holograms. A few interesting examples there is the Burberry check, which is registered as a trademark. One of the Cath Kidston soldier designs. Fred Perry there has got a position mark for the crest and the stripes on the sleeves and the collar of a t-shirt. And then Tiffany is an interesting one because they actually have a trademark registration for the Tiffany blue, which you can see on the left-hand side there. And they also have various registrations for their boxes and pouches. And it just shows that they consider those elements to be very important for their branding, and also that consumers recognize them as such. So I'm going to talk through the two main types of trademarks, registered trademarks and unregistered trademarks. As the name suggests, a registered trademark is something you apply for, and in the UK, that's via the UK Intellectual Property Office. You file an application, and provided all runs smoothly, you then obtain a registration certificate at the end of it. On that registration certificate, you're going to have the trademark and the name of the owner, so it's a clear-cut ownership, and it gives you a much stronger legal position and more control to take action against third parties. In comparison, unregistered rights arise through use of the mark. So to prove those unregistered rights, you're going to have to compile evidence to show when you've been using the mark and in relation to which products. So it's going to be cheaper and easier to enforce a registered right, given that you just need to show a registration certificate versus compiling a whole load of evidence. Having a registration can also work as a deterrent to third parties, because you can start using the R in a circle as opposed to the superscript TM. And I think by using this kind of terminology, it just shows that you're IP savvy, it shows that you know what you're talking about, and it could mean that third parties just decide to stay well away. And having a registration also allows you to register your brand at customs. So in the UK, this means that border control can monitor imports coming into the country, and if anything looks suspicious or counterfeit, you as the trademark owner will have the right to be alerted to that consignment, and you can order its destruction if you consider it to be counterfeit. So what you can do is inform customs of any holograms or swing tags you're using on your products, so that they can identify any legitimate products and become more autonomous. Having a trademark registration also allows you to register online platforms such as the Amazon brand registry. And again, this just gives you more control to take down counterfeit sellers and stop the counterfeits at source. And then finally, if you're looking to export into other countries, have distributors and retailers in other countries, then you may find that third parties won't even engage in conversation with you until you can show that you have a registration in that country, and China is somewhere in particular we've seen that. So overall, having a registered trademark just adds value to your IP portfolio and facilitates those kind of expansions and doing deals with third parties. So in comparison, unregistered trademarks arise through use of a mark. In the UK and also in other countries, this is the case. But as I've said, this is all evidence-based, so it's time-consuming and costly to prove and to enforce. It's great that they arise automatically, but they shouldn't be relied upon. It's important to note that registering your company name at Companies House, registering a website or setting up your social media handle doesn't provide you with any trademark protection, and it's only the subsequent use that starts building up unregistered rights. And also important to note that some countries, specifically China, don't recognise unregistered rights at all. So it can be very difficult to take action against a third party if you don't have a registered trademark. Even if you've been using a trademark in China for 10 years and you just haven't got around to filing an application, if someone else files an application for your mark, then you're very much on the back foot. So I just wanted to run through some recent examples to illustrate why it's a really good idea to get your registered trademarks in place and to do it early. So Rihanna was able to stop TopShop selling these t-shirts with her image on them, and she was actually successful based on unregistered rights via a passing off claim. But I wanted to flag this one because it's a very unusual case, and in theory it is more difficult to win a case based on unregistered rights. So although she was successful, the court made it very clear that she was only successful because of the very specific matters of the case. And in this case, it was because Rihanna had previously done a tie-up with TopShop as well as other high street retailers. So it wasn't beyond the realms of possibility that consumers would think that Rihanna had endorsed that t-shirt. And for that reason, she was successful. Another case to mention is Bentley Clothing versus Bentley Motors. Bentley Clothing being a small family-run business that registered a trademark for Bentley in that hexagonal shape in the 80s. And after that, Bentley Motors, the well-known car manufacturer, started using and tried to register Bentley in relation to clothing. And this is a really good example of how even a small company can prevail based on registered rights if you get your trademark in early. So it made no difference that Bentley had a huge reputation in relation to cars and had probably a lot more money to throw at the case. But because Bentley Clothing had their registered rights in place, they were successful. So it shows the strength of trademark rights and the benefit of getting your application in. Another example, Michael Jordan versus Chiaodan, which is a Chinese matter. And this, again, is a lesson in being proactive and filing applications early. As I mentioned before, China doesn't recognize unregistered rights. So in this case, it didn't matter that Michael Jordan had a reputation in the US and Europe, and maybe that he'd already been selling in China under his well-known shoe brand, because Chiaodan was still able to file applications in China for various Michael Jordan trademarks, including this figure, as is shown. And it's been very difficult for Michael Jordan to get these trademarks back. It's obviously been going on for a long time, since 2012, and all the while that's going on, you have no control over your image in China, what products are being sold and the quality of those. So it can lead to huge consumer confusion as to what are legitimate products and what are counterfeits. And we have seen in China where these squatters file applications and then try to sell the trademarks back to their rightful owner for huge amounts of money. So after an 8-year battle, Michael Jordan is starting to make some traction and get some positive results through the Chinese courts, but it's very difficult. It's been very costly and obviously very time consuming. And this could have been avoided by filing applications early on at a fraction of the price. And then finally, Adidas versus shoe branding. Adidas failed to maintain this 3-stripe registration on the basis that consumers didn't recognize it as belonging to Adidas. So this doesn't mean that Adidas can't still use their other 3-stripe registrations, including the more slanted registration, which I think is more synonymous with Adidas, but it does make it more difficult for them to stop third parties using more generic 3 stripes, such as this one. And in this case, shoe branding was using a 2-stripe mark, which again, Adidas are going to struggle to take action against. And this is good to illustrate that the more distinctive a trademark is, in theory, the easier it's going to be to protect and enforce, because you don't need to show that it's acquired distinctiveness through use, and it's going to be easier to build up that reputation as associated with you as opposed to any of your competitors. So it's worth incorporating this into your design and branding strategy from the outset, and just starting to think about how easy a trademark is going to be to protect. So just to run you through some practice tips for brands and trademarks, taking those recent cases to illustrate some points. Identify your trademarks early and check that they're free to use and register. As trademark attorneys, we can advise as to whether a trademark is going to be free to use and if you're going to infringe on third-party rights when you launch. Assuming you're free to use, then we always recommend filing applications early in your core markets to avoid having to rely on unregistered rights, particularly in countries that don't recognise unregistered rights. The more distinctive a trademark is, generally the easier it's going to be to protect and enforce. In relation to fashion houses in particular, fashion companies tend to be named after their designers. So if you do have a relatively common name in a particular country, then it might be more difficult to protect and enforce. So it's worth thinking about that early on as to whether you're going to trade under something slightly different or you're going to add another element to your name to make it easier to protect. And then it's important to regularly revisit your filing strategy, because it's not a one-size-fits-all. It's going to change based on every product and every country that you expand into. So you need to make sure there's no gaps in your protection and your business plan fits with your IP strategy and vice versa. And then finally, you want to ensure that agreements are in place with any parties who you're doing collaborations with or your contributors, so that it's clear who owns the resultant IP and to future-proof yourself against any fallouts or issues in the future. So we thought it would be helpful to take you through a crossover creation, given that there is some crossover in between design protection and trademark protection. And my colleague Heather's discussion talks about this in some detail. So we're just going to focus on the trademark angle here. But a single product might require multiple different forms of IP to properly protect it. There's a particular grey area in relation to the protection of shapes. Designs are potentially the more obvious route, but they can be registered as trademarks in some circumstances. It's less common and it's potentially a higher hurdle because you need to show that that particular element is distinctive as originating from you, and it has to depart significantly from the norm. So you wouldn't be able to get a shape trademark for a generic garment shape. It would have to be something that's really quite unusual. So going back to the Valentino, intricate studded pattern to it, lots of different straps and a huge amount of surface decoration, and it helps that Valentino have been using that shape and selling those shoes for quite a long time, so it is synonymous with coming from them, and that would be why it's registered as a trademark. So in the Louboutin case, Van Haren, who were a Dutch shoe company, argued that Louboutin's red sole couldn't be registered as a trademark based on the shape provisions, and it was excluded from registration. But Louboutin successfully maintained their registration on the basis that this mark didn't exclusively consist of a shape. Given that there was a colour element, it couldn't possibly exclusively be a shape, and it was therefore validly registered. So this is a positive decision for fashion designers, because although these kind of marks still aren't the norm, it's positive to know that the courts are starting to recognise these as being able to function as a trademark. So it means that all of the time and investment that Louboutin has put into producing these high-end products and marketing them can be protected, in that they now have more leverage to be able to stop third parties from selling shoes with a red sole. So the important points to note here are that you may find you have an item, a physical thing of some sort, which goes beyond just the aesthetic appeal and actually conveys your brand identity as a trademark. So this could be a whole product, or more likely the part of a product, such as the red sole or Burberry's check fabric. And ultimately, it would be best to obtain registered trademark protection for that item, because this can last indefinitely, and it's not reliant on the item's appearance being considered novel or original. But it has to be distinctive and convey that the product originates from you. So while trademark protection can be difficult to secure in the short term, because you need to show that you've built up that acquired distinctiveness through use, it's good to try and think about that and to aim for that if you can. But then if you don't obtain any registered protection at the start, and copycats and counterfeits are allowed into the market, it can be much more difficult to get a trademark registration later on, because it's harder to demonstrate that items of this sort are actually recognised as coming from you as opposed to your competitor. So there's that dilution in the marketplace. It would therefore recommended to get a registered design in place at the outset, as once you have that protection in place, you can still stop copycats in the short term, and you can preserve your position for an eventual trademark application. So there's a two-step approach there to try to protect yourself as fully as possible, and you can bolster your protection by having multiple different types of IP on the same product or part of a product. So just to look at some key takeaway points from the seminar. The first is to not rely exclusively on unregistered rights. While it's great that they arise automatically and the IP system recognises these, and so it can help bolster your IP protection as a whole, generally speaking, they're more difficult and more costly to enforce, with a greater uncertainty as to the outcome. So it's really recommended to try and get registered protection wherever you can and wherever is most appropriate too. Secondly, we recommend being proactive and putting an IP strategy in place. So you've thought about all of your options and you know why you have or haven't done something. In relation to products, there's potentially a two-level approach that you rely on or you obtain registered rights for your core pieces or your house marks, whereas the other shorter-lived items such as seasonal or one-off promotional items that don't justify the spend in obtaining registered protection, you might decide to rely on unregistered rights instead. And in relation to brands, again, consider your house mark and your sub-brands and the elements of those products which are going to be important for you long-standing, and get registered protection for those rather than having to rely on unregistered rights. And finally, we recommend seeking professional advice early on whenever you have a new product or a brand to protect, and then continually as you branch out into new countries or you have new brands coming out, just to make sure your strategy is working for you. There's no one size fits all, and it's worth adapting this, so seek legal advice. So that just about brings the seminar to a close. Thank you very much for your time. If you'd like to find out anything more about IP, there's lots of information on our website. We have lots more expert talks on YouTube, including the seminar by my colleague Heather on designs in relation to the fashion industry. Or feel free to contact us directly either by email or via LinkedIn with the details up on the slide there. Thank you very much.